Hello everyone, welcome to Management 413, Employment Law, here at the UAB Ch School of Business. In this video, we will be covering the employment relationship using Chapter 2 of our textbook. Here are the topics we will be covering in this video. Make sure you understand what those are. It's very important that we know whether a worker is an employee or not. This is important for several reasons. One would be the tax laws. For example, Social Security only applies to employees. Workers' compensation, that is compensation if you are injured on the job, only applies to employees. Most rules that govern the performance of a worker apply only to employees. So we need to know who is and is not an employee. The other category of a worker would be an independent contractor. Both independent contractors and employees work for the employer, so we have to look for other factors to figure out who is an employee and who is not an employee. There are several tests that can be used. One test is called the economic realities test. Look at the factors here. How much control does the employer have as to when and where the work is done? Is the payment structured so that it's a flat fee, or might there be a opportunity for a loss if the work was not done properly? How long is the working relationship? The longer the relationship, the more likely it is to be an employee. How integral is the business that the worker is doing to the employer's overall work? If it's the heart of what the employer does, it's more likely that the worker is an employee. Here's another test called the common law test. You can see that there are very many of the same factors used in this test as in the economic realities test. Perhaps the most important issue would be the amount of control over where, when, and how work is done. It is not possible simply for an employer to label a worker as an independent contractor in order to avoid the employee-employer relationship. But if the worker is willing to be labeled as an independent contractor, a well-drafted agreement should spell out exactly what the worker's duties are and acknowledge that the worker is an independent contractor. Here's an interesting example in the workplace today. UPS considers its drivers to be employees and pays half of their Social Security tax. The employees can sue under laws like Title VII of the Civil Rights Act of 1964 that gives rights to employees. FedEx Ground, on the other hand, in exactly the same business, calls its employees, or calls its workers, calls them independent contractors, and they have fought for years in court over that, and most recently they have been winning. FedEx Ground has been winning. They make those workers buy their own trucks, buy their own uniforms. They say that they can deliver whenever they want. They can hire other people to help them. All of those factors make them independent contractors. Take a look at the case in the textbook involving a company called EGL, where they found that there was an employment relationship in a freight pickup and delivery service. Here's an interesting look at the future of our economy. Increasingly, we see companies like Uber having their workers labeled as independent contractors and not employees, and many people might step back and say, well, that's the wave of the future. I don't think that that's necessarily the case. Here's an example of another so-called new economy job, Instacart, which I guess is a grocery shopping service. That company decided that its workers should be employees. Here would be the type of things that you ought to specify in a valid agreement that makes somebody an independent contractor. Have them provide their own tools, let them hire their own assistants, pay them a flat fee. Some companies, like Microsoft, have attempted to get around the employee status by hiring people on a long-term basis, but calling them temporary workers, not employees. Sometimes at Microsoft they were called permatemps. They were not successful in doing that. The rule would be that you can't arbitrarily exclude people from the benefits simply by calling them temporary workers if they're going to, particularly if they're going to be there over a long period of time. Here are some interesting applications of whether or not somebody doing work is an employee or not. Graduate students and teaching assistants are usually considered students and not workers. On the other hand, medical interns and residents in hospitals are usually considered employees. Northwestern University's scholarship football players felt that they were doing a job and should have the rights of employees. However, as recently as August 2015, the legal system disagreed with those football players, and they are primarily students and not employees. Interns, many of you have been or will be interns. Should they be considered employees and have the rights of employees, such as benefits and the right to sue for illegal discrimination? The Department of Labor has provided some factors that might help figure out whether someone is an intern or not. I think the most important factor would be whether or not the internship was really designed to be educational, or was it really just low-level work for the employer. Take a look at the Fox Searchlight Picture case where some students were interns at a movie production company and should have been considered employees. What about volunteers? There might be a great number of volunteers in your organization where you become an HR professional, such as hospitals. You can see the picture here often has a great number of people who serve some very important patient interaction functions, for example. Uh, should they be considered employees in terms of their treatment and getting the protection of the employment laws? You can see here what factors are used. Are the benefits that they receive really significant, or are they just inconsequential incidents of an otherwise gratuitous relationship? I think it's harder to prove volunteer status at a for-profit firm than it would be at a not-for-profit firm like a hospital. Sometimes the question of the employee-employer relationship comes down to whether the person or the organization you are working for is really your employer, or the person you would like to sue is really your employer. This can be difficult in large interrelated organizations with lots of separate corporations spread out across the world, where you might see that there is a deep pocket somewhere else in the corporate structure other than your direct employer, and you might want to try to say that all of those companies together are your employer. The law of agency is important when deciding whether or not there might be liability in the employment context, because an employer will be liable if the worker is an agent acting within the scope of his or her employment. You might recall, particularly if you took legal studies 246 from me, the movie Fast Times at Ridgemont High, in which the character you can see here was leaving work at the direction of his boss and delivering fast food. When he decided to throw all the fast food out the window, if he had injured someone, he probably would have created liability for the employer because he was acting within the scope of his employment. That's it for this set of slides. In our next set of slides, we will be looking at employment discrimination Has it really ended? How do you prove illegal employment discrimination?